We're here in cause number 19-32623, and we have had some discussions in the back that I think we need to put on the record with regard to the case and where we are. We have, first of all, sir, you're Dalvius Williams.
Yes, ma'am.
And Mr. Williams is here with Mr. Rojas. Mr. Smith is here on behalf of the state. There is a second amended motion to revoke unadjudicated probation. So because the new allegation, I'm not going to accept the plea agreement of the cap of 4 years because there's a new. So I will allow, if Mr. Williams wants to withdraw his pleas of true to 1, 2, and 3. I can go through those again and get pleas today on those, and then we can go forward with what we have today. And then if I feel like there needs to, it's my understanding, Mr. Smith, for today, you have witnesses with regard to proving up count 4 only. Is that correct?
That's correct.
So what we can do today, depending on what those pleas are, either way, we'll go forward with what we have because there's witnesses here. And then if I feel like I need to postpone the hearing to another date for the state to prove up more, then we can do that then. So, Mr. Williams, the best you can, I need you to raise your right hand, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You can put your hand down. And so, Mr. Rojas, what is y'all's position?
Judge, I think after discussions with Mr. Williams, I think he would like to withdraw his plea of true to count number 3.
Okay. So just to go back, count 1, Mr. Williams alleges that you violated your probation by failing to report to the probation department October 25th and December 15th of 2022. You had previously pled true that that was true. And do you want to continue to plead true to that count?
Yes, ma'am.
Okay. And then count 2 alleges that you're behind in your court-assessed fees as of January 4th of 2023 in the amount of $3,638. You previously pled true to that count. And do you want to continue with your plea of true to count 2? Count 3, which was in the added in the first amended motion, alleges that you committed the offense of evading arrest or detention July 14th of 2024. You had previously pled true to that count, and do you want to change your plea of true in that count?
Yes, ma'am.
You want to change your plea to not true?
Yes, ma'am.
Okay, so we'll enter a plea of not true to that count. And Mr. Smith, I know you weren't prepared, I guess, for that, but have y'all had any contact with the officer? I would think that would be a one witness.
It's actually several witnesses, Judge.
Okay.
They're going to serve a warrant at his house. There were 2 officers in the back that see him come out of the back of the house.
Okay.
Knocking on the front door, so we need both of them.
Okay. Okay. All right. So we'll see where we get today then. Mr. Williams is on probation for possession of a controlled substance, and that, which was a 3rd-degree felony, correct? No. That's
Yes,
been, oh, it was as well. I've got the indictment pulled up from the injury to a child. That's a 3rd-degree felony. But that possession of a controlled substance is a 3rd degree as well. So the range of punishment is between 2 years and 10 years. And Mr. Williams, I also want to make sure you understand that if we go forward with this motion and I do end up revoking your probation, then later, if the state does prove, so we have the injury to a child, that new case, if you're found guilty in that new case, then the punishment could be stacked. Do you understand? Do you understand that?
Yes, ma'am.
Okay. Mr. Rojas, you've gone over all of that with him, correct? And it's also my understanding that y'all had, even in the back, Mr. Williams' mom in the back to go through everything, what his options were and all of that this morning. Is that correct as well?
That's correct,
Okay. What if any offers? I want to make sure Mr. Williams on the record rejects anything that's been offered.
We had offered 4 years in this case, Judge, and he is rejecting that offer.
Did that include an offer in the injury to a child?
Actually, I offered 4 years in both cases to run concurrently.
Okay.
If he went today.
Okay.
He said no. And I told him that if he didn't do that, if we go to trial on the new one, I would move to stack that case on whatever he gets in this case, and the 4 is off the table in this case.
Okay.
I apologize, and I didn't hear what the last part. Did Mr. Smith talk about the 4-year offer for today to the possession of a controlled substance? And if he were to be tried in the future, if he were to be convicted for the injury to a child, that case would be stacked? Did you say that?
He would request it, and it's up to me. So anytime the state asks for a case to be stacked, it's up to the court to do that. So it's not up to a jury. If you go to a jury trial on that injury to a child, what would happen? Let's say you go forward today, we have this hearing. If I revoke your probation and give you any time in prison, then the next step would be to set that injury to a child for a trial. And then if you're found guilty in that case by a jury, then what the state is saying is that they would ask me then to stack that, whatever sentence you might get, if you get a sentence, on top of what happens today in the motion to revoke probation. Do you understand? Okay. And so your options are today, if you wanted to go forward with a plea in both of your cases, plea of true in that motion to revoke for a 4-year sentence, plea of guilty in the new injury to a child case for a 4-year sentence, with the agreement that those sentences would run at the same time. You don't have to do that. We've got witnesses here. We'll go forward with the hearing. Just want to make sure you understand what your options are today that you won't have after today, and what your consequences could be if you go to trial and if we go forward. And nobody's trying to talk you into anything. I just want to make sure you understand it all. Does that make sense? Okay, so you understand everything that's been offered and what what you could do today and kind of where we're about to go, right? And so what do you want to do?
True to first, but not to the injury to the child.
Okay, then we'll go forward with this hearing. So I want to make sure also for the record what all I've reviewed. The original PSI, obviously from being placed on probation, is included with the updated pre-sentence report. Everyone should have that as well. And so when I went back through that, I just want to make sure that there aren't any corrections or issues with regard to that criminal history specifically that I'm looking at. It starts on page 1 and then carries on to page 2 on that pre-sentence, or actually it was a post-sentence investigation, I think. Y'all have that? Everybody's on the same page as me?
Yes, ma'am.
So it looks like there was adult misdemeanor history of 2 thefts back in 2013. Both of those were 30 days in jail. There was a theft of services in 2014 where Mr. Williams received a probation. That probation was revoked in 2016. That's in Rusk County. Possession of marijuana in 2014, Nacogdoches, 3 months in jail. A resisting arrest or search, March of 2015, where there was a probation given that was revoked in 2018. There was then a 2015 failure to appear bail jumping case in Nacogdoches. 2016, burglary of a vehicle, 30 days jail, and then 2019, a resisting arrest again and an evading arrest also in 2019, both with 180 days in jail. Then the felony criminal history I show is a criminally negligent homicide from 2017, where a probation was given in 2018. That probation was revoked in 2020. Looks like that probation was revoked based on, and looking back on all of this, I'm not real sure other than what we were all thinking, but it looks like on January 10th of 2020, The probation was revoked on the criminally negligent homicide. There was a new offense of injury to a child that he appears to have pled guilty on and received a 12-month state jail sentence. There was another offense, new offense, from January of 2019, an attempt to take an officer's weapon, also same disposition date of January 10th of 2020 for the 12 months in the state jail. And then there was this possession case that we're here from that same date. So it looks like he took some time on a couple of things and then got probation on the possession. Does that, everybody on the same page as that?
Yes, Your Honor.
I did look back. I think because I have this information, I don't think it's necessarily improper for me to look at some of the information based on those cases. I do have a question specifically with regard to the injury to a child from 2020 that he pled guilty on. What is the relationship with, that was the victim in that offense?
It's a stepson, Your Honor.
So Ms. Broussard has other children
Yes.
that are not from Mr. Williams?
At least one, Your Honor, yes.
So when we went back through, Mr. Williams entered pleas of true to counts 1 and 2. So I am going to find, based on those pleas, counts 1 and 2 true. Count 3 entered a plea of not true, as well as on count 4. I am going to find, based on the evidence presented today with regard to count 4, that there is sufficient evidence to find count 4 true. And at this time, I am going to find count 4 true. I understand everyone's position. I think with regard to, there'd be different evidence, I would think, and probably more potentially at a trial. I'm not required to look at all that, and obviously the level of the burden is different. So count 4 is true. Mr. Rojas, you may proceed with argument.
Judge, when we did the initial plea, we got the updated PSI report, and they were recommending that if probation were to be granted of ISF. Obviously, that can't happen with a new charge pending. He does have this new injury to a child that after speaking with the family, I don't think he's going to be able to bond out even if you were to keep him on probation. If the court is inclined to keep him on probation without ISF, we ask you to do that. If that's not going to be possible, Judge, we ask the court to consider something in the range for the possession case, 2 to 4 years.
All right. Thank you, Mr. Rojas.
Judge,
Mr. Smith?
I believe his criminal history shows fairly convincingly that he is unable to successfully complete probation. Speaking of probation officer, I don't believe it's their desire to keep him on probation with this type of charge pending, especially in light of the fact that he's already been convicted of injury to a child within the last few years. That tends to me to show more than just a pattern, it's a habit. The fact that he doesn't respect authority is shown by the jail incident reports. I feel like he needs to be revoked in this particular case, and we're asking for no less than 5 years, somewhere between 5 and 10 years as punishment in this particular possession.
Thank you. And also, just for the record, everybody has those jail incident reports. Those were provided. I've reviewed those as well. Mr. Barksdale's here. Mr. Barksdale, do you, the probation officer, do you have anything to add at this point with regard to your position?
No, ma'am, I concur with the district attorney.
Okay. Thank you, sir. Mr. Rojas, I would give you an opportunity if you want to. We can ask Mr. Barksdale to come if you have any questions of him.
No, Judge.
Okay. And Mr. Williams, you're 30 years old?
Just make that one.
You just turned 31. So I appreciate that you have support here and people here to support you, but your behavior to me tells me that you shouldn't be around any children, much less your own. Whatever is happening with you when you're getting angry at these children with what you're doing, because it's the same, This appears to be the exact same type of incident that you pled guilty for a few years ago when I put you on the probation for the possession. And this, it's ridiculous. You and Ashley both don't need to be around any children. Don't need to be having more children. You can't take care of your own children, and you're disciplining them by doing this. And I don't think there's any reason for anybody to believe that no one said these are scratches. That's not what the doctor said. If there are, they're adjacent to these other marks on the back of this 2-year-old. Going to find, again, that you entered your plea of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find count 4 true. Find sufficient evidence at this time to find you guilty of possession of a controlled substance. I'm going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. I'm making a notation on this because originally it was a plea agreement that when it was signed, I'm making a modification. Let me change it. This was not a plea agreement, so you do have some rights to appeal. I'm also going to hand you a written admonishment regarding, hold on a second, regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Rojas. Thank you all. I'm sorry. I know this is difficult for everyone, but I have no doubt in my mind that Mr. Williams, not just on this occasion, but probably on many, has obviously improperly disciplined, if that's what you want to call it, all of these children. So, court is adjourned.
All right.